Welcome to the Fear and Greed Business Interview. I'm Sean Aylmer. We often talk about class actions on this podcast, a claim made by a group of people against a company or an organisation for some kind of wrongdoing. But we haven't talked about the way this kind of litigation is often paid for. Litigation funding is an asset class for investors, one uniquely tied to the legal system. Remember, this is general information only, and you should always seek professional advice before making investment decisions. Stuart Price is the Chief Executive Officer of CASL, one of Australia's leading litigation funders. Stuart, welcome to Fear and Greed.
Thank you for having me.
Let's start with the very basics. What is litigation funding and how does it work?
Litigation funding, we have one of the most advanced legal systems and some of the best laws in the world. But unfortunately, it costs a significant amount of money and has a significant amount of risk attached to it. That means that it is often reserved for some of the most financially resourced, best resourced companies in the world.
Mm-hmm.
What we provide litigation funding is the capacity and ability for other people to bring cases against these types of companies and enterprises that have large financial resources and to level the playing field. Really, it allows people to access the legal system without taking on the financial burden or the financial risk.
Okay, so what types of claims and actions are you talking about here?
The types of actions and claims that we are generally fund are class actions. Now, this might be against shareholder securities class actions, which are misleading, deceptive conduct on the ASX, the stock exchange, or it could be consumer class actions or indigenous class actions, non-securities class actions, which is very much the growing area. We also have commercial claims, breach of contracts. We could have insolvency claims for breaches of directors' duties, really anything which is likely to go through the legal system and has a good prospects of being successful, we're willing and able to look at it.
Okay, so are there any that we might know of, even if they're not settled and they're allegations until they're proven one way or another, but are there some out there that you can, and a couple of examples?
The career highlight that I had, and I think this is really one of the best examples of litigation funding, was the Queensland stolen wages. So this was a claim by around 14,000 Indigenous individuals and their families for wages that they earned but did not receive between 1939 and 1972. That was at the period where they were under the Protections Act. We funded that class action in my previous organization, and that resulted in a settlement of $190 million. That was the fifth largest class action in Australia's history, and the largest human rights class action of its time. So that it really, in a nutshell, is one of the most historically important class actions, but it also demonstrates the power of being able to bring the funding and also the capability to prosecute these claims on behalf of a group of people that individually or collectively weren't able to provide the financial resource to do so.
Stay with me, Stuart. We'll be back in a minute. My guest today is CASL Chief Executive, Stuart Price. So I want to get to litigation funding as an asset class in a moment, but before we do that, how does CASL judge whether or not to take on a client/class action?
Absolutely. Well, we've had 25 years, in excess of 25 years of doing that exact step. The 25 years has really refined our selection process, and I like to refer to it almost as the John West approach, which is we do decline a lot more cases than we select. So it's a very high bar to be funded. That's an important consequence for the other side, the defendant, to realize that it has reached that bar. But we look at factors such as the area of law, the types of claims that are being prosecuted, the evidence. We look at the financial metrics of the cost of prosecuting it versus the likely claim size. We look at the parties to make sure that the parties on the defendant side are able and capable of paying a resolution. And we look at qualitative factors like, are they likely to, for instance, continuously appeal and take matters as they're allowed to do all the way through to the High Court. So we look at a number of factors, built over 25 plus years of case selection. That case selection, we've achieved a 92% success rate in our selection. So from my perspective, what we're doing in selecting cases, we're doing really well.
Okay, and you get paid if you win, presumably. So 92% of the time, you're getting paid. Is that how that works?
Absolutely. We only get paid when the case is successful. That's important because we're absolutely aligned with the claimant, the group members. We put our financial resources behind the case, and we bring also a lot of experience and skill to the broader legal team on developing the strategies to prosecute the case most efficiently. But the important part you touched on there, we only get paid at the end. And generally in class actions, we only get paid to the level that the court determines is fair and reasonable. So there is important governance, checks and balances imposed by the court.
Okay. What about on the investor side? And I know that in recent days you've launched a fund that will be used for new actions. As an asset class, how do I think about it? Is it a defensive asset class? Is it something that, it's long-term, presumably? I'm just, as an investor, how should I think about this?
It's definitely an asset class which I find is really interesting when people dive into it. It is an alternate asset class, and is probably one of the most vanilla alternate asset classes that exist. It is uncorrelated to the stock exchange or bonds or property. There will be litigation that arises at all points in time. And there are, like I've described earlier, cases that arose from actions back in 1939 to 1972 being brought in the modern time. So as an asset class, there is a great deal of breadth and variety to what is provided. There is some degree of predictability and certainty. The predictability is the laws are very well developed. There certainly is no guarantee about the outcome, but in that John West approach, one of the factors that we do adopt is making sure that there's a greater probability of success than otherwise. But as an asset class, the predictability and the almost guaranteed that the court will manage the case all the way through to the end as efficiently as possible. So you don't have the court taking its time and allowing defendants or plaintiffs to waste time. They want to move things as efficiently through the court system as possible. So as an asset, an investment class, an asset, it is very attractive for sophisticated investors. I think when you identify that we select on average about 5% of the cases that come to us for funding, that from an investor's perspective, they have a basket of cases that we invest in. There's not a guarantee that every single one will win, but on the balance of probabilities, we will win, and we expect to win much more than we lose. And historically, that's produced a very attractive return profile for investors.
Okay, so in terms of Australia as a country vis-a-vis the US and some of these other developed nations, is this something that are we further developed than those nations? I'd imagine that the US would be more developed, and is that give us some sort of insight into how Australia will perform as an asset class?
There's two answers to that. Australia was the first to introduce litigation funding, and my business partner, John Walker, was really the initial pioneer back in 1996. So globally, litigation finance arose from Australia. The size and scale of the US and its reputation for litigation is partially a reflection on the nature of the jurisdiction. There is no adverse costs in the US, whereas there is adverse costs in Australia. And what that means is you can bring an action in the US, lose, and have no downside. Whereas here in Australia, you bring an action, lose, you wear all of the costs that you've invested as well as the costs of the other side. So fundamentally, we've got different jurisdictions. Australia led the way in the world and, from my perspective, has the most developed legal system and also some of the most sophisticated litigation funders in the world.
What I think I've learned today chatting to you, Stuart, is the governance around litigation funding here is a lot more rigorous than I actually expected. The other thing we haven't spoken about is the good that this asset class can do for individuals. Obviously, the Indigenous Australians that you were talking about between 1939 and 1973 or 4, whom weren't paid the right wages, they got money from that. But I mean, there is a public good in what you're doing.
Absolutely. I mean, the governance improvements are very notable from the way that companies, governments, insurers, how they treat other parties. So you really have that rebalancing of the power within the legal system. So from my perspective, it's a necessary part of the social fabric of Australia to have litigation funders and the abilities to hold these large enterprises to account. Some of the examples that I've mentioned and some in the future will only arise because of the presence of litigation funding. And I think that's a really good thing that people know and should know that if they do bad things or wrong things, they will be held to account and there's a means and mechanism to do so.
Stuart, thank you for talking to Fear and Greed.
Thank you very much.
That was Stuart Price, co-founder and CEO of litigation funder CASL. This is the Fear and Greed business interview. Remember, this is general information only and you should seek professional advice before making investment decisions. Join us every morning for the full episode of Fear and Greed, daily business news for people who make their own decisions. I'm Sean Aylmer. Enjoy your day.